Welcome to Trial Lawyer Prep. What if you could hang out with trial lawyers and jury consultants? Ask them about connecting with clients and juries more effectively. Then take strategies, tactics, and insights to increase your success. Each week, Elizabeth Larrick takes an in-depth look at how to regain touch with the everyday world, understand the emotional burden of your clients and juries, and use focus groups in this process. Elizabeth is an experienced trial lawyer, consultant, and founder of Larrick Law Firm in Austin, Texas. Her goal is to help you connect with juries and clients in order to improve your abilities in the courtroom. Now, here's Elizabeth.
Hi there, it's Elizabeth. I wanted to jump in before we start this episode and tell you a little bit about my guest, John Prudhomme. He is with CPM Injury Lawyers. He got his undergrad at the University of California, went to law school at SMU School of Law, and has been in the Austin area for many years now, has tried many cases of lots of variety. He and I have worked on a few, and we will talk about that in the episode. If you have questions for John or want to get a hold of him, just know his contact information will be in the show notes. Okay, let's get to it. Hello, and welcome back to the podcast, Trial Lawyer Prep. I am your host, Elizabeth Larrick, and today we have a guest joining us, a very good friend who's local. I know we have a lot of folks that come in here recently. We had people from Montana come, but now we've got a nice local Austin lawyer joining us. Hello, John. How are you?
Doing well. How are you?
Doing great. Trying to get through this heat a little bit. If you're just now listening to this episode, when it comes out, it'll be July. I think it's the week of almost July 4th. If not, you're catching up. Hey, listen, it's in Texas. Today, I think they're forecasting the first 100-degree weather day. So we got a little warmed up.
For a while.
Yeah. But I wanted to bring John on because his firm has done focus groups with me before, but he has had one that's come all the way to the gamut. They went to trial. And so I really wanted to bring him on to talk about it because he had a pretty interesting piece of evidence that we sometimes find in our cases, which is video footage. And so we want to talk about that. I wanted him to talk about his experience and kind of give y'all kind of a backstage view of what happened and how the virtual focus group helped and kind of how we set it up. So, that's what we're here to talk about. So John, tell me, now, first of all, let me give a little background. So I'm really not even sure how Chris and I think Chris just can't remember how we ended up getting connected. I want to say it's probably through BNI, which is a business networking thing. And he came to me and you guys had a super complicated medical device. And guys, this was complicated. Like there were just drilled in the brain and had lasers. And so it was this super complicated thing. And so we ended up doing several really long ones, right? So we had these long ones and they ended up having a very good result in that case, but we had a little different thing here. So tell us, John, a little bit about the case and how come you wanted to do a virtual focus group.
Sure. Yeah. So this was a very different case from that medical device case. That was a wild one. I think we focus grouped like 4 different theories of that case, trying to figure that one out. Yeah, so this one was much more straightforward. This is a fuel tanker rear-ending a dump truck on I-35. Seemed from our perspective to be pretty straightforward. We had a video from the dash cam of the oil tanker that we thought made it pretty clear. Video showed our guy going pretty slow, but the oil tanker essentially just plows into the back of him. So it seemed pretty straightforward. And then we got 2+ years into the case and we hadn't gotten an offer and everyone seemed to be digging in on the other side that this was a disputed liability case. And so while we thought it was pretty straightforward, I definitely started to get a little bit paranoid, especially as we started to get, I think, maybe 3-4 months out from trial. And there didn't seem to be any indication of a settlement coming at any point soon. So that's when we reached out to you to see, hey, can we get a group of people in here to get another perspective on what the defense might be looking at from that side and what a jury might think of that video.
Yes. And what John is being so polite about is it wasn't just that it was a video. Okay. And it was a nice, crisp video, by the way. This wasn't like one of those crummy ones. And also his client was getting on the interstate, y'all. It's not just driving real slow on there. It's getting on. And the fact was that turned out, like, why did this happen? It was the fuel tanker driver was sound asleep. Totally admitted he was sound asleep. So looked like super clear liability. So John comes to me and he's like, I must be missing something because there's no offer. Feels like a super clear situation. We got video. So we said, okay, let's throw it to a focus group. But also, I think the other thing that was a little bit precarious was the venue, right? So venue a little bit north of us. That's just different venue, I will say. It's a few different factors that you guys want to make sure because, sometimes we can spot what the fence is hanging their hat on and sometimes we can't. And so this is one of those places where, like you said, they litigated for 2 years. And originally, of course, the position originally was, okay, dude says it's 100% his fault. He's sleeping. And now it's a 50-50 situation. So a couple of things just to test out. So we took it to the focus group and we did a pretty simple, straightforward, right? Didn't want to put our fingers on the scale one way or the other. We just did pretty neutral, straightforward things. So I had some people from the venue. What were you going to say, John?
Oh, I was just going to say, yeah, we had one of the first depositions in the case was a company rep for the oil tanker company saying that it was 50-50, which we thought was great for us. And then as we got a year longer into the case, and all of a sudden nothing had changed as far as they were going. We were trying to figure out, so they were serious about the 50-50.
Yes. So we get in the focus group and, John, you're watching, right? What were some of the things going through your mind as you're watching these folks digest, I should say, into the video?
Well, yeah, and so the way that you did it was you showed the video and you asked them what they thought about it, and that had me terrified because they were willing to put a decent amount on my client for what speed they were going at that point. At that point, they didn't have the knowledge that he was asleep. That did certainly change their mind a little bit. But I mean, even after we went through the different iterations as they learned more about the facts, they were still ready to put at least 5-10% at a minimum on my guy, despite the fuel tanker driver falling asleep behind the wheel of a loaded fuel tanker. So that was pretty surprising and a little discouraging, but it certainly gave us some insight as to at least where the defense was coming from, what to expect from a jury up there, because like you said, it was a group of people from that area. And most importantly, told us that we needed to change what our strategy was as far as approaching for die or opening, and obviously our plaintiff direct. And I think this was before we had taken liability expert depots in the case. And so that allowed us at least a little bit of runway to change some of our theory on liability that we thought was just, we had already checked that box.
Mm-hmm. Right. And mostly for liability, but we also did a little bit of damages work too. So what was it that were some takeaways about the damages that the focus group told you?
Yeah. And so for damages, I mean, when I first reached out to you, I asked you purely about the video. I was just getting a little paranoid about liability. And I think we talked a little bit about damages then, but wasn't really thinking too much about focus grouping damages. We had a veteran as a client who was, had a back surgery. He had been recommended for spinal cord stimulators. He had done the trials. He had been through quite a bit of medical treatment. So we weren't terribly concerned about that, but we decided to at least throw in a little bit at the end. And that also was extremely helpful as far as figuring out where to focus, because they were less interested in the treatment that he had. And they ended up being far more interested, and this is credit to you, Elizabeth, in his family and how it was going to affect his family, and kind of the change from being, this guy was essentially Paul Bunyan before, and the way that his family was going to be impacted as far as his inability to do things moving forward. They were far more focused on that, which ended up being true of our jury in this case than they really were as far as what he was dealing with on a day-to-day basis, which ended up being extremely helpful as far as, again, his direct. We shifted things around as far as what the plan was there.
Yeah. You ran into the collateral source problem.
Well, yeah.
Which with the military thing in here, and just give you guys a little kind of behind the curtain, this particular venue is a very good thing because you're going to have veterans on the panel. You're going to have people. So it was like, okay, like we want to make sure we talk about this. And then of course, the flip side of that is, well, we got some collateral source things pinging around in people's brains. And of course it came up, and naturally, wasn't it even remotely true for the case, John?
Yeah, there was no insurance coverage whatsoever, let alone the collateral source issues that they were concerned about. It ended up getting worse when we got to trial, when most of our panel ended up being employees of the VA and the local hospitals around. So just kind of compounded itself.
Yeah, also a problem, right? So tell me a little bit about, I mean, we ran this group, anything else that, like, thinking at that time that you walked away with thinking, okay, we're going to need to move some things around. Anything else that were takeaways from the focus group that you guys changed things for your trial approach?
The approach on liability, the approach on talking about his family as the one being impacted. I mean, obviously, we get so caught in the weeds as far as we're looking at a jury charge, which is what are his damages? What is he dealing with as far as medical expenses, pain and suffering, impairment, those types of things. But that doesn't mean that that's necessarily all that they want to hear about. And so really, like, that was one of the biggest things that changed. I know I already mentioned that. As far as new things, honestly, the only on liability, just to kind of dig into that further, we shifted our liability approach to focusing on, I think it was something that you brought up when you were talking to them, that really, it's funny to watch them work in real time as they're talking through the issues. And the issue of the highway not having a minimum speed was something that was pretty surprising to everyone. And it became a huge deal for them in the focus group. So we made it a huge part of we took it a little bit further. We pulled out the statute on obstructing the roadway and started and focused on that hard with the defense experts, with our expert, and, really hammered it home throughout opening. And pretty much every witness that we had related to liability, it kind of shifted our entire approach to how we were dealing with the liability aspect. The one thing, I would say that I wish we had focus group more, we talked about it a little bit, but I wasn't too worried about it, is they had done surveillance, which we definitely didn't give as much attention to as we should have. And it ended up being a pretty big deal for the jury. Made some bad rulings on that we weren't really expecting, but I wish we had spent a little bit more time getting people's thoughts on that part of it. But yeah, I mean, those were the two big things, is focusing on the impact to his family, and then just really shifting our liability focus beyond, hey guys, he was asleep. Do you need any more than that?
Yeah. And that's what I was going to say. Like, the other thing that was, like, super surprising was, and again, if you drive up and down 35 often and frequently, like, it's a blur. So we had one person plant this idea that there is a minimum, and then everyone adopted it. And it was like, and I had to say, like, okay, there is no minimum. Okay. Just so we're clear. But people, like, so that was a huge thing that, like, kind of caught traction. And it's one of those things where it's like persuasion, right? Like, that had so much credibility over, right? Like, literally the video of, like, this dump truck is getting up to speed to get on the highway. And they, so I think that was like, okay, all right, this is good. This is something you could never have predicted that they were going to create.
Yeah, right.
Create a law that was going to penalize your client.
They couldn't have cared less that he was getting up to speed. It didn't matter to them at all. I guess people have enough experience on the highway, or at least on this highway, that they were so annoyed that he was going not close to the actual maximum speed limit that they put all that stuff out the window, and they just focused on the fact that he was going that speed. And yeah, really, that minimum speed thing really got in their mind and took off for a while, I think, until you told them there was no minimum speed limit, which is why we took it further when we went to the trial and said, this is the law on obstructing the roadway. This is the law on impeding traffic. He wasn't doing any of these. We got their experts to agree that he wasn't violating any laws with how he was driving that day. I think that helped turn it a little bit. But man, I will tell you, people do not like people driving slow on the highway. It's apparently more offensive than falling asleep behind the wheel.
That's what that was my other comment was, when we think about doing an 18-wheeler case, a commercial vehicle case, like we kind of look for these like, distracted driving. Are we fatigued? And sometimes we get that out of people that say, oh, well, was he over hours? Like very kind of rarely, but it happens. But in this situation, there literally was 100% proof. The guy had signed on a statement, I fell asleep. And they were not concerned one iota about this guy and being over hours or anything. And
yeah,
no concern there, like more pissed about the guy in the dump truck.
I know. It's like we spend all this time digging into these facts. Fell asleep. This is the best case, all that stuff. And I just feel stupid every time. Like we got to talk to the jury afterwards, the focus group. And it's like the people that are making the decisions on these cases, they don't care about that stuff at all. Everything that we get so excited about.
Yeah. I mean, the other thing too that we really wanted to test, which was the flip-flop, meaning they were, yep, I fell asleep. It's written in my company, in the company policies or the after documents that they fill out. And then we go to depositions 2 years later and it's no. Like this was definitely this guy's fault. He had a mechanical error, which there was zero proof of any kind of mechanical error. But was that okay? And they were just like, yeah, we expect that. Like we expect companies to totally flip-flop on you and say that. So it really wasn't, they expected that kind of behavior. And I see that often in focus groups where we're trying to see, does this have traction? Like, does this make people upset? And they've now come to just, that's accepted.
And the focus group ended up being consistent with trial. When we talked to the jury afterwards, they loved our guy. They thought he was credible. There was nothing about what he was saying that they thought wasn't truthful. And they hated the corporate rep for the other company, the same guy that testified to 50-50. They didn't like him at all. It didn't change any of their thought process as far as liability. Nothing at all. They thought he was asleep. They didn't think for a second that he wasn't asleep. They didn't buy they came up with this theory that he had just dozed off and he wasn't fully asleep. They didn't buy that at all, but it still didn't change your guy was still driving too slow.
Mm-hmm. Mm-hmm. Yeah. Okay. So let's flip to trial. You guys get to trial. You've got this panel and you're thinking, okay, we had a panel. This is on steroids, worst kind of panel we want. So tell me a little about, and again, just for you guys, like, don't, in anticipation, the jury actually didn't get the case, right? They end up settling right before closing argument. So, and, we're not going to talk about that. That's confidential. However, we get to talk about everything else. And I'm so excited that you guys talked to the jurors to get their feedback. So tell us a little bit about the makeup of the jury and kind of how it was, the focus group panel on steroids, basically.
Yeah. So it was 6 men, 6 women. Really, I think we had like 4 nurses. We had 2 hospital administrators. We had it was awful. We almost busted the panel. And this was the good panel. This is the good 12 that we ended up with. Not even joking. It was an insane panel. But so we ended up with 4 nurses, 2 hospital administrators, a billing person at a medical practice, 3 VA administrators, 1 guy who just wouldn't answer any questions and didn't fill out his jury questionnaire.
Oh my gosh.
And I don't know how he ended up on there. And then we had one other, I think he worked at Tesla. It was like a plant operator at Tesla or something. Anyway, so
a great panel. So it sounds perfecto.
Yeah, it was pretty terrifying. We were definitely scared of them the whole time. We definitely were trying to, with all the nurses on there, we definitely tried to focus more on the severity of the injuries and the medical, maybe a little bit more than we had planned, because it wasn't really a tug at your heartstrings type of group. One thing I will say for them is, man, they listened to everything. They were intent. No one was dozing off. There was they were all, and when we talked to them afterwards, they were all fascinated by the case. A little bit more so than I would have hoped. I would have thought it would just be more outrage at the guy falling asleep behind the wheel, but we did not get any of that. But just a brutally bad.
And then you mentioned kind of one of the, now there were a couple of less than desirable rulings that you guys got. And one of the probably the bigger ones that probably couldn't anticipate, because I feel like the law is really clear in Texas, which is the admission of the full police report, which is like pretty much never happens. And so that had some nuggets that planted some seeds that couldn't really be overcome because there was literally no evidence anywhere, right?
I think that's the thing that probably hurt us the most on our guy's speed is there was a part of the police report that mentioned our guy having mechanical issues, which, like you mentioned earlier, there's zero evidence of any mechanical issues. And so that got in front of the jury. Obviously, once they finally, that was the other thing is we didn't know it was getting in until the third day. And so we couldn't plan for it.
Oh,
Just assumed it wasn't.
right.
But yeah, we couldn't get a ruling, case law, and he held it. And then the third day, we finally got that ruling. But it was a little too late to do damage control or to do too much damage control. So that was pretty harmful. I think that's probably what hurt us a decent amount as far as, well, obviously, I don't know what the jury would have done, but at least in our minds, it hurt us a decent amount on the speed. So yeah, we had that one that was pretty bad. And then you mentioned collateral source. We had a pretty bad collateral source ruling where one of their experts was allowed to testify to what for example, an epidural steroid injection reimbursement from a health insurance company would be just for the physician, not for the facility. So the only evidence that they have is our bills, and the reimbursement rate for those bills for a physician would be $200 or something like that.
They were speaking straight to that billing juror right there, like, hey, there's nothing to be done. Tell me a little bit about the surveillance, because I know that this is an issue that a lot of people face. And it's unfortunate that sometimes we get that surveillance literally on the doorstep of trial. Like, oops, here it is. We, surveillance them for 2 weeks. Like, we didn't see it. What was kind of the nature of the surveillance?
I'll just kind of back up a little bit because our guy, like I said, he was basically Paul Bunyan, Army Ranger, all this stuff. And so he doesn't look hurt when he's sitting there on a day-to-day basis.
No, when he says Paul Bunyan, this person 6'3", almost 6'4", and just, a brick wall of muscle. And I did see pictures of him working out. He did like to do some muscles and do the weightlifting. So, okay, back to you, John.
Yeah. And I mean, he hasn't, obviously he hasn't worked out since the wreck, but I mean, when you've got 25 years of that type of intense routine going on, it doesn't just go away overnight. So, so he didn't look bad, and he could still obviously do a lot of things that, a lot of us can't do now. So he, the surveillance showed him, lifting up bags of ice and bending over and picking up an ice chest. The thing that we did have going for us is he did have a spinal cord stimulator in at the time, and he was, I think, like 5 or 6 months post discectomy. So, we addressed the surveillance through his doctors. These are the things you would expect them to be doing, that type of stuff. But, he's also a pretty successful guy. And so he's got a boat and he's got nice cars and he's got an awesome family. And so the part that hurt us, I don't think was necessarily what he was physically doing. It was that this guy looks like he's living the life. Why are we going to give him this much money? And that was the biggest part. That another ruling that we thought would go our way is that, we didn't expect them to show a picture of the boat. They even got to ask him how much the boat cost. Do a couple different things there that we just were never anticipating would actually get in and should have planned for better. Most likely, it certainly influenced the jury as far as what they would be willing to award. And so, honestly, as we sit here today, I don't even know how we would address those specific aspects of it. I think we pivoted pretty well as far as addressing the physical limitations that he had and why he was doing some of the things he did versus what he was able to do before through through his surgeon, through the life care planner, talking about those types of things. But I would have been a lot more comfortable if we had figured out through a focus group because when we talked to the jurors afterwards, the surveillance was a pretty big deal. It was meaningful to them. And I think at least I, a lot of times, discount it because, it's sleazy, it's shady, people see it that way. And they did, but then they also actually watched it.
Yeah, but then they were also putting it in both categories, like, well, the good and the bad.
Exactly. That's the best way to put it. There were so many things that I think we see sometimes as black and white. This is either good for us or bad for us. And man, they put it in both categories a lot of the time.
Yeah. And so I think one of the things that we talked about was you guys did get to talk to them afterwards. We've talked a lot about that, but tell me a little bit about kind of the feed off of them that you guys were thinking as far as like verdict amount, which end up probably being like, trust your gut. That's why you went ahead and got it settled. So tell us a little bit about their feedback on numbers.
Yeah, I think we probably would have ended up maybe about half of what we settled for as far as a verdict goes. Very, very happy we were able to get it done before it went out to them. Yeah, they weren't buying the numbers. We had a life care plan with a great life care planner, the both categories thing. They loved our life care planner. They thought he was the best witness of the entire case other than our client. But they were not buying the amounts. We talked about the nurses and the administrators and things like that. Maybe it's a county thing, but they were not buying the full bill charges. Collateral source injected into the case or not, it just wasn't something that they were going to be willing to go with. Mm-hmm. So,
which let me just pause there, which was really important for your client because he had done these trial spinal cord stimulators. He refused. I wouldn't say refused. He made a choice. He's not going to have narcotics. He's never going to take narcotics because he had small kids, teenagers at the house. So his thing was, I'll try the spinal cord stimulators, which worked. However, by the time trial came, he had not gotten the permanent ones. So the permanent ones were in there. And that was really probably the most important thing I would say. Yeah, for him, because, he was a nice guy, didn't want a lot for pain and suffering. And we fashioned that with our focus group, by the way. We really looked at, okay, here is what he needs. And there really wasn't in the focus group. There wasn't a lot of like guff about it, right? Other than like, wait a second, he can go get this, with the collateral source thing. Like, oh no. So anyhow, just wanted to like plant that in there because the life care planner was a really big piece of like, hey, this has to happen in order for him to have relief, so.
It was the biggest part of our damage model by far. We put a lot of effort into that. We put a lot of effort into, kind of focusing on that in open and obviously through all the doctor's testimony as far as trying to prove up the life care plan, including the defense experts. And that was the crazy thing is we didn't really have a whole lot of dispute as far as the actual treatment that was going to be needed in the future for him. They had 4 medical experts. 3 of them agreed that he was going to need essentially everything that was in the life care plan. It came down to the cost. And so they weren't sitting there saying, the jury wasn't sitting there saying, we don't think he doesn't need any of this treatment. It's just, he's not going to have to pay this amount for this. And so we're not going to award him that. That really ended up being the biggest deal. We were never able to really get over that collateral source in their mind.
Plus the boat.
Going out and buying a boat while you're getting all this treatment with a bunch of medical bills sitting out there probably ended up being our
well, and that's also one of those things where, when thinking now that you've gone through, you actually got to you saw their case, right? And then you got to hear what resonated. Like they had a lot of riding on your guy and him being super active and buying a boat and like the surveillance, which, a lot of them do that. But, when all their experts agree, you're not really with your experts. There's not like, was that really what they're hanging their hat on? And it was, and they did it.
Yeah, it's funny. Again, we get so caught up in all this stuff. We spent so much time trying to figure out how to get to all of their experts. And really, at the end of the day, the jury didn't care about any of their experts. They cared about the boat. They cared about the costs. And they just cared about what he was physically still able to do for his family. And they saw him moving around in those videos. And I think it hurt our argument that, he's not going to be able to do these things in the future. He's young too. And so they're not seeing what it's going to look like in 15, 20 years. And, we tried to hammer that home with all of our experts and doctors and even the client up there. But yeah, I definitely would say I'm guilty of focusing way too much on trying to get to their experts and what our guys are going to say, and not really focusing on some of these things that ultimately matter to them more. And the surveillance is one of those that definitely don't spend enough time addressing.
And I think, it like people are like right now and in the past year, like people are very conscious about costs and expenses. And when they go to the grocery store, it goes up. Like when they get the gas pump, not so much, but the groceries and like I think that it's like they're so much more cost conscious. Plus, you had, unfortunately, a jury full of experts on that kind of stuff, and then they are not as empathetic, like windfall or whatever. So the other question that I have, because again, you've got this great experience of, we talked about your client before, we talked about the focus group and kind of what his perspective was. How did his perspective change, like going through trial lists and everything? Like, how did his perspective change about his case?
He was very, very involved in this case. Great guy. One of the better clients I've ever had, for sure. Very smart, which sometimes can be difficult to manage expectations, especially because he knows exactly what's going on. And so we had talked about the focus group in pretty good detail. We picked the jury. The jury, he didn't really totally understand what was happening with the jury for the first couple of days, though, I would say. He also gave one of the best directs that I've ever seen anyone give. It was incredible. And so they really liked him. But I think he started to see and his wife was very helpful in helping him get there on this. He finally got to the point where, we didn't really have any sort of offer to consider until we started. We were going to close on the Monday after we started. And so we got back in the courtroom on Monday, and that was the first time it was going to go to the jury at 9 a.m. that we got our first real offer. And so he didn't really have anything to consider before then. That was the point, I think, where he was finally able to realize, like, oh, this jury is terrifying. We had talked about it a little bit on Friday. We had talked about it a little bit over the weekend, but we didn't have a choice. So there wasn't really much context to have that discussion. And then when we sat down and we're really talking about, whether we want to put this in their hands or not, they were definitely both able to acknowledge, I don't know what they're going to do. And it could end pretty poorly and could end significantly less than, they were never going to pour him out or anything.
Yeah.
But it might have been a lot less than we were talking about it as far as the stuff. So yeah, he kind of saw the evolution, and then he didn't talk to them, but he overheard them talking to the defense attorneys afterwards. And I don't think he could have ever been happier about a decision he's made.
Yeah. Again, you have this unique experience that things do settle quite often, like in the middle of trial, but most of the time it's at a different point, not right. So, it is sometimes happen right before closing, but when your client gets that experience and then the sitting as a fishbowl and like seeing how it's all swirling around and thinking like, this is not at all what I thought was going to happen, but again, you guys didn't have even a single offer to consider. So it wasn't like there was any kind of waffling because like, hey, we're going, like, this is it.
Yeah,
so
yeah, no, absolutely.
Super helpful. Okay. Awesome experience here. So, you got to go all the way through, obviously thinking back, not that we're, using hindsight, probably would have done focus group on that surveillance to see how it would have nailed and how you could have because again, as we heard in your focus group, just on your video for liability, we had people on both sides of the coin, right? And they're tussling it out, and hearing basically their strong points and why and all that good stuff. And so that's, helped you kind of shape where we had to go and what we had to lean into. And hopefully the surveillance would have provided you kind of the same thing. Because normally they do, right? You're going to focus group hopefully is good. There's a good mix that you're going to have people on both sides and they're going to be talking about their opinions either way. So anything else you feel like you would have focus grouped or maybe?
I'm wondering, on the surveillance, funny.
Well, yeah, definitely on the surveillance. I think you said, if there had been more time, then you would definitely have done one on the surveillance.
So just one note I also learned at trial on that surveillance is, so they brought the PI alive and he testified that he had done surveillance on our guy a week before trial. No video, shockingly produced, which is interesting. But yeah, so, I think I talked to my client about, I don't think they're going to, probably not going to be any more surveillance at this point. I was wrong. Definitely need to note that in the future. As far as focus grouping stuff, I think we've been trying to figure out different ways to address the elephant in the room as far as health insurance or lack of health insurance and stuff. I think that might be, I don't know if that's a full half-day focus group or it's worked into a damage focus group, something like that. But
right.
There's definitely need to figure out some better way, at least. I don't know. And maybe it's just not possible with certain juries, ours in particular. But, figuring out some way to better address that you can't consider health insurance in this case, or you need to not consider it, or however we need to get there from that perspective. The method we tried was through some of our doctors, but it clearly did not land with them.
Well, and again, you had expert jurors, so that's, I think with a different panel. But again, it's kind of one of those things where, holy moly, I know you guys tried to bust the panel and the judge is not going to let you do that. But, that's kind of one of the other things too, is one of these gambles that we have, especially with this. And here in Texas, we have this, like the war is on the bills right now. And like, everyone's got a billing expert and it's this, it's that. And, and that's where if you're running a car wreck, or any kind of that's where they're kind of staking a little bit of a claim, which makes a lot of people worried. We've done lots of focus groups on these billing experts and the challenges and stuff like that. And so, I think it's a matter of figuring out how to talk to people.
Yeah. And, I think we've gotten decent at least at attacking the billing experts and undermining their credibility. And I don't, honestly, their billing experts didn't have credibility with the jury when we talked to them. I don't think that was meaningful to them. Mm-hmm. I think it's just, frankly, the defendants would have been better off not bringing billing experts because it was already in their mind. It was something that was going to affect their result anyway. I don't know exactly what the path is, but I think I've definitely spent way too much time trying to figure out how to attack their billing experts and less time focusing on how do we address that elephant in the room through our people, because that seemed to be the much bigger issue for them.
Right. And that's a lot of the results that we've seen is this is a side issue. You're trying to you're kind of distracting me from this other thing. 'Cause anyone can come in and say, it should be less. Right. But ultimately, who has the ability to negotiate? Right. And that's you're asking your client, right? Did you negotiate this? As we sit here today, if you go get this in 6 months, do you have any idea what it's going to cost? No. What are you relying on? Well, the guidance that I've gotten from this guy who that's his whole job, right? And, if it's more, if it's less, it's kind of one of those things how do you, where do the seeds plant? And I think you've nailed it, which is, I think it's almost everybody, right? It's your doctors, it's the life care planner, it's even your client, because he is fine now, but he's a young guy. And it could be, because he wakes up one morning and it's different. That's happened to him before.
Yeah, no, exactly. That happened a lot during this case.
Yes. Awesome. Well, hey, I really appreciate you coming on and sharing your experience. I know a lot of people are curious about virtual. You guys have been early adopters. And I think, thinking through this case and why you came to do one and just to be, totally black and white here, John did not do an all day. We did 2 hours. That was it. And in those 2 hours, this is all the nuggets that he got to really reframe liability.
Yeah, I don't think, frankly, because we did at least one in-person focus group. And honestly, I don't think it, from the other case before, I don't think it changed anything to have it virtual, really. watching them work, thinking through these things and talking through these things is fascinating. You learn quite a bit about how we get lost in our little bubbles, our little legal bubbles. When we
Yes. Yes. Well, I'm just thinking through, like, if we had wanted to do one for in person, like that would have been an exponential larger cost because we all would have had to get in our cars and go up there and get a place, and versus having everybody tune in on Zoom, which convenient for sure. So awesome. Well, John, if there's anybody out there listening who may be on the fence about virtual focus groups, like what advice would you give them?
Yeah, I would encourage you to do it if you've got anything that you think is going to be a potential issue in your case, or you're curious about how a jury is going to think about it, or step back for a minute because you think something is all locked in, and maybe reconsider as far as the different ways that people might think of things outside of our lawyer world. Yeah, I definitely encourage you to do it because it definitely changed our mindset on this one. And if we had approached it kind of with the fastball, this guy fell asleep and screw the rest of you approach that we were kind of going with it, I think it would have turned them off quite a bit. So yeah, I would definitely encourage you. If nothing else, it's fascinating to hear how they think about things, and it'll certainly change at least one or two things about the way how you approach cases.
Awesome. All right. Well, thank you so much, John, for joining us today. I know it helps to hear other people's experience, and you had a pretty fun one here recently. And this was just in May, right? So I mean, we're digging the gold out now before we move on to that next case. So thanks so much.
Wild ride. Finish June 1.
That's right. All right. Well, thank you all here for listening in to this episode. If you have questions about John and his case, maybe you have a similar case, which actually happens pretty often when I have my listeners email me and say, ooh, you talked about that. All of John's contact information will be in the show notes. I know he is happy to talk about the case and how they did approach things and what they use. So if you want to reach out to him, his contact will be in the show notes. Also, if you're curious about doing a virtual focus group and maybe want to dip your toe in the water, there'll be a link there if you want to talk to me about doing one of those. Like John mentioned, like I mentioned, got all kinds of styles and flavors for everybody out there. So if you have a question or if you're curious, please book a time to talk to me. It's for free. Other than that, if you like this podcast, please rate, review on your favorite platform. That helps other people find it. And until then, thank you so much.